We're getting great Second Amendment court decisions. This is great news. And what's even better is that the methodology that the various judges are applying, even when they rule against the Second Amendment, is very favorable to us going forward when it comes to protecting our rights. I'll explain when we get back. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and New York Times best-selling author. If you haven't subscribed to the Four Boxes Diner Second Amendment channel, I plead that you do so. We're trying to get to 100,000 subscribers, which I think will make a big deal with helping us spread the word with the various algorithms that apply to this channel. All right, folks, we've had some great Second Amendment decisions, but remember, it's not just the outcome that counts. We want to win every single case involving the Second Amendment, 100% true. But we also want to make sure that we are establishing strong precedents, not just for the outcome in favor of the right to keep and bear arms, but also the methodology, the process, or the criteria that will be used going forward to decide Second Amendment cases. Because if you get a very favorable criteria or standard that's helpful to the Second Amendment, it makes it a lot easier to win future cases, not just today's cases, but future cases. And I think the Supreme Court in NYSRPA versus Bruen did a really, really good job of setting up a criteria that's very favorable and appropriately so, in my opinion, to protect our fundamental Second Amendment right to keep and bear arms. So again, remember, NYSRPA versus Bruen set up a framework, a criteria or standard by which Second Amendment challenges to modern-day gun control laws should be filtered or considered by sitting federal or state judges. And what the Supreme Court said quite clearly was that individuals in the United States have a right to keep and to bear arms. To keep means to possess, to bear means to carry in public, all for the purposes of self-defense. And the only time that the government can possibly infringe upon those rights, it's not that they're infringing upon the rights, it's the only time those rights can be limited in scope is if the government can demonstrate that in 1791, at the time of the Second Amendment being written, the public understanding was that certain restrictions on the right to keep or to bear or to carry or discharge guns, whatever, was understood to be the case as very limited restrictions. There were some restrictions. So if there are long-standing regulations of firearms going back to 1791, continuing to this day, that is understood to be outside of the scope of the Second Amendment. There's not a lot of them out there, but there are some of them. Again, we also know that NYSRPA versus Bruen pointed out, this is very important, that there's no more balancing test. What a balancing test is, when you talk about the right to keep and bear arms, is arguments to say, yes, Mark has an individual right to keep and bear arms. You have a right to keep and bear arms on the one hand. But on the other hand, there's certain social benefits associated with regulating firearms or banning firearms or restricting firearms that we're going to balance the benefit or the importance of your individual right to have a gun and to use a gun for self-defense against the importance of being able to regulate these guns in the name of some sort of public policy or governmental policy. Now, the Supreme Court said this is not allowed. It never was allowed. It should not have been allowed. And the fact that courts did this after Heller was unacceptable. And the reason why is that the Supreme Court specifically said that when the Founding Fathers wrote the Second Amendment and the rest of the Bill of Rights, they engaged in a balancing test. The Founding Fathers did, along with the Americans at the time. They balanced the interest of having, an armed citizenry on the one hand against, any public policy problems on the other hand. And they did the same with the Fourth Amendment involving unreasonable searches and seizures, the First Amendment, so on, so on, so on. So basically, the Supreme Court said in Heller that the Founding Fathers had already engaged in the balancing of the individual rights against societal interest, and that has to be respected. And unless somebody amends the Constitution using Article 5 procedures, sorry, you have to respect the right to keep and bear arms, and no more court balancing tests are permitted going forward. And I think that's very good for us. That's why when I tell you, whenever you hear the words tiers of scrutiny, you run like heck and you point out to anybody, even if they're good on guns, that is a mistake, that is wrong, that is terrible thinking, and that is just a fact. And the only people that would support that, I understand why over the years people have naively embraced that for various reasons. I'm not beating them up or attacking them for doing that. It was wrong then, it's wrong now. And the good news is the Supreme Court has agreed with my view of things and has rejected those tiers of scrutiny. But if you hear anything about tiers of scrutiny, intermediate scrutiny, strict scrutiny, you run for the hills. That is extremely bad for the Second Amendment and the right to keep and bear arms, because you're given permission, you're giving license to government judges to engage in balancing tests of your rights against government interest, and you never, ever, 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 ever want to allow that, because inevitably, as we've seen historically, the government judges will rule in favor of the government interest over your individual rights almost every single time. And don't kid yourself. Anyone that says that's not true, to me, is analogous to a person that says socialism has never worked in the past. Yes, but my version of socialism is going to work this time if we just do it right. That's, to me, the same way that you see people that say tiers of scrutiny can work for the Second Amendment. BS. It's never worked in the past. Socialism's never worked in the past. Anyone that says tiers of scrutiny is good for the right to keep and bear arms, you tell them no way, no how. It's no proof of that. Never been proof of that. And we don't want to do that. And the good news is the Supreme Court agrees with me. So basically, it doesn't matter what they think, because the Supreme Court set forth the standard that tiers of scrutiny is no more, cannot consider it. So even if you disagree with it, the Supreme Court's on my side. So just cite to the Supreme Court. Now, we recently talked about the Range versus Attorney General case. The Range case was a nonviolent felon case in the Third Circuit Court of Appeals in front of three what I would consider to be anti-gun or gun-skeptic judges, two of which were appointed to the federal bench by Barack Obama, the third by George H.W. Bush, that's Bush the first. I don't think any of them are good on guns, and I don't think their ruling is going to ultimately stand up to the test of time. But set that issue aside, even though I think they came out on the wrong decision involving nonviolent felons and reached the wrong answer, some of the things they said was quite good for our side in terms of methodology. I just want to point out some of the things that they wrote that's were quite good. So what the Third Circuit, which again, this was not good judges on the gun issue, but they still said good things for our issue. This is what they said. They quoted Bruen, and they says that a firearm regulation can only stand if it's consistent with this nation's historical tradition. That is the only way. If a firearm law regulation is consistent with the tradition in American life of regulating firearms, then it can overcome, so to speak, the Second Amendment. Basically, it can limit the scope of the Second Amendment as understood in 1791. Also, the Range Court in the Third Circuit said that the Constitution presumptively protects individual conduct once the gun control regulation touches the text of the Second Amendment, and the government thus, once the modern-day gun control law impacts the Second Amendment's right to keep and bear arms, then the burden shifts, if you will, or the burden resides with the government to demonstrate that the modern-day law is somehow consistent with the long-standing regulations of firearms consistent with American history, which is very difficult to do. And how do they do that? Well, the Range Court correctly said that the way you figure it out is through looking for historical analogues. In 1791, in the late 18th century, is there a historical analog or a law that's very similar in 1791 to a modern-day gun control law? If the answer is yes, then it's quite likely that the gun control law today can stand Second Amendment scrutiny. If the answer is there is no historical analog to the modern-day gun control law, then that gun control law today is struck down as unconstitutional. What the Range Court said, and quoting Bruen, that even if a modern-day regulation is not a dead ringer for historical precursors, it may still be analogous enough to pass constitutional muster. But what's also significant, and now I'm going to quote Judge Sinatra in the Western District of New York, when he struck down the private property gun control regulations. As you may recall, there was a ban in New York that said that you couldn't bring guns into a store. The presumption was that if the store didn't put a sign up that says guns allowed, and you brought your gun, even with a concealed carry permit, on private property of a store, then you were committing a felony. And that was flipped. Judge Sinatra says that's not how it works. In a free society, you have the freedom to do whatever you need to do unless it's banned. Therefore, unless someone bans you from having a gun, the store says you can't bring a gun onto your property, you are allowed to bring a gun onto private property unless you're told you can't. That the government with Kathy Hochul, the New York State government with Kathy Hochul, actually got that backwards, and that's what Judge Sinatra says. But Judge Sinatra said some other very positive things consistent with what the Third Circuit said in Range. Specifically, what he points out is that What's quite significant is the Supreme Court's recognition that when a challenged regulation addresses a general social problem or societal problem that has persisted since the 18th century, the lack of a distinctly similar historical regulation addressing that problem is relevant evidence that the challenged regulation is inconsistent with the Second Amendment. And then Judge Sinatra goes on to point out that the regulations trying to ban guns on private property without a sign that says you can bring guns onto my property, what Judge Sinatra says is that's trying to address a social problem called handgun violence, meaning using firearms for the purposes of committing a crime or a violent crime. And he points out that there was violent crime in the 18th century, in 1791, that they tried to stop, and there's violent crime today that we try to stop. So it's the same exact social problem that we're confronting today. And yet back then, in 1791, they did not try to ban guns or prevent you from carrying guns. In fact, if anything, they encouraged it with the Second Amendment, just like what we should be doing today. And Judge Sinatra points out that trying to restrict people from carrying guns today, there is no historical analog to a late 18th century gun control law. In fact, it's just the reverse, because even though today we face violent criminals, back in 1791, they faced violent criminals. And again, at the time of 1791, they did not try to ban guns. That proves that any attempt to do so or to restrict where we can bring guns violates the Second Amendment. Remember, there was plenty of violence in 1791 in the colonial period. You had Indian attacks, of course, obvious examples of violence involving all sorts of weaponry. You also had the fact that Georgia, remember, the state of Georgia was originally envisioned to be a penal colony, right, full of prisoners. And, Great Britain, England at the time, brought thousands upon thousands of, convicted felons and criminals to the United States, the same way they sent them to Australia. So we had plenty of bad dudes here in the United States, and there's countless stories of extreme violence all around the United States in 1791 and the colonial period, not just from Indians, but also from outlaws and criminals. And of course, animal attacks as well. Plenty of examples of that. So plenty of reasons why we needed firearms to protect ourselves against violence in 1791. Judge Sinatra recognized this fact and says these are not new social problems. They didn't go to ban guns or restrict where you could bring a gun back then. So you can't do it today in the 21st century, because as the Supreme Court points out, if the founding fathers faced the same social problems that we face today, but they didn't use gun control, then gun control today is not allowed either. Now, what's also very interesting about Judge Sinatra's opinion, which I think is, again, very helpful for understanding the methodology going forward in applying the Bruen case, Judge Sinatra talked a lot about the relevant historical time period, and he seems to have agreed with me considerably, because we've hammered home this is so important that we focus on 1791 to look for historical analogs and not the late 19th century. So the anti-gunners want to use 1868 and thereafter to find historical analogs, because there is more gun control law then, mostly because it's noxiously created. There were gun control laws in the late 19th century to try to stop the freed American slaves from having guns after they were freed, and also there was a lot of anti-Confederate animosity after the Civil War. That part's understandable, but you had a lot of attempts to try to disarm Southerners after the Civil War. Again, a historical, weird, anomalous period, not really anything speaking to the tradition of regulating firearms in the United States. And again, we've talked about why it's inconsistent. If you have one version of the Second Amendment, historical analogs from 1791 applied to the federal government, and then you have another version of the Second Amendment from 1868 that applies to state, city, and local governments, you really have two different versions of the Second Amendment, one for the federal government with certain analogs, and then another for the states with different types of analogs. You can't do that. That violates basic black letter Supreme Court precedent, which is very clear. And it turns out that Judge Sinatra, now you've got someone much better than me to talk about who's agreed with me, and that's Judge Sinatra in the United States District Court for the Western District of New York. Because here's some of the stuff that Judge Sinatra said, which clearly shows that he agrees with my viewpoint. He writes when he addresses because what happened was New York was trying to use late 19th century historical analogs to justify their gun control laws, and Judge Sinatra, when he struck them down, says, no way, no how, it doesn't work. Here's what he writes. The additional late 19th century enactments cited by the declaration submitted by New York, these were not expressly addressed in the Antonyuk case. They were not generalized private property enactments, but were enactments focused on large gatherings, etc. So he distinguishes it. But then he goes on, and this is the key. Judge Sinatra says that all of these vastly post-date the Second Amendment. Obviously they do, because these laws that New York was trying to justify involving their gun control laws came in the late 19th century, which is like 100 years after 1791. So that's why Judge Sinatra says that these laws, these historical analogues that New York was proffering, were, quote, vastly post-date the Second Amendment. Then Judge Sinatra goes on to say, it bears consideration of what a court might do if they were addressing an 1880s era enactment in real time in the 1880s. Here's what he writes. The court would be expected to ascertain the meaning of the Second Amendment right codified in the Second Amendment. It would not be impressed by 1880 era laws in effect in neighboring jurisdictions that contravene the earlier public understanding of the right. Do you hear what he just said? He's pointing out that 1880 laws, to the extent they existed, would be inconsistent with the understanding of the earlier public understanding of the Second Amendment. That's what he just said. And he goes on to say that the Supreme Court in Bruen noted that, quote, when it comes to interpreting the Constitution, not all history is created equal, close quote. By the way, are you familiar with a powerful scholarly argument by a handsome YouTuber with the title, Not All History is Created Equal? I think you are, because I think you've all read it. That's right. I put a link to it down below, the article I wrote 2 months ago on this very topic. A great quote by Judge Sinatra. He continues on. Constitutional rights are enshrined with the scope they were understood to have when the people adopted them. And when did they adopt the Second Amendment? In 1791. Hello, that's what the Supreme Court says. It's not that hard, anti-gunners. Please learn your lesson, anti-gunners. Judge Sinatra continues on. Courts must also guard against giving post-enactment history more weight than it can rightly bear. In other words, Bruen recognized that where a governmental practice has been open, widespread, and unchallenged since the early days of the Republic, the practice should guide our interpretation of an ambiguous constitutional provision. Now, we know that Americans have been carrying guns peaceably for self-defense since the beginning of our country. Anything that shows that that's not consistent in these handful of terrible states like New Jersey, New York, and California, that is inconsistent with the traditions of the United States, and Judge Sinatra recognized this. And I'm going to leave you with this powerful language, okay? This is what Judge Sinatra says. He has clearly got the point, and I hope other judges follow this methodology. It's very powerful and very favorable to the right to keep and bear arms. Judge Sinatra says that because post-Civil War discussions of the right to keep and bear arms took place 75 years after the ratification of the Second Amendment, they do not provide as much insight into its original meaning as earlier sources. That's what Judge Sinatra says, quoting the Supreme Court. He gets it, that post-Civil War history is just not as persuasive as 1791 history, which we must focus on, which is very good for our movement here in the Second Amendment. Judge Sinatra continues to say that although it is the 14th Amendment that requires New York to respect the right addressed in the Second Amendment, the court has made clear that individual rights enumerated in the Bill of Rights and made applicable against the states through the 14th Amendment have the same scope as against the federal government. The Supreme Court has, quote, generally assumed that the scope of the protection applicable of the right when the Bill of Rights was adopted is 1791. Did you hear that? 1791, Judge Sinatra points out that the same meaning of the Second Amendment in 1791 as to the federal government has to be the same when applied against the states. The original understanding of 1791. And then Judge Sinatra concludes, if this were not the case, meaning if the Second Amendment and the 14th Amendment did not have the same meaning as to the meaning of the Second Amendment in 1791, this is what Judge Sinatra concludes. If this were not the case, the Second Amendment could mean one thing vis-a-vis federal laws and entirely something else vis-a-vis state and local laws, period, close quote, Judge Sinatra, Western District of New York. Judge Sinatra gets it. Very powerful precedent that I think other judges will be able to use across the United States. It's Judge Sinatra and even the Third Circuit, even though I disagree with their decision in Range. I think between the Range case and Judge Sinatra's decision, very powerful methodology explaining that the presumption is really we have the right to keep and bear arms, that violations are not to be accepted unless there is a longstanding historical tradition, and that tradition is measured by looking for historical analog laws that are the same or equivalents, at least, of modern-day gun control laws, but to the extent they existed in 1791, and to the extent they do not exist in that late 18th century, then that means modern-day gun control laws should fall because they're unconstitutional under the Second Amendment. Okay, I know this is kind of a long, complicated, geeky little topic, but it seems to be that a lot of the stuff we're talking about on this channel is being embraced by courts, not just the Third Circuit Court of Appeals and Range, but also by Judge Sinatra in the United States District Court for the Western District of Missouri and striking down a bunch of New York gun control laws, and I applaud him for that. Great news. I think this is all good news for the right to keep and bear arms and their fundamental rights under the Constitution. Okay, so hope you learned something. If you haven't subscribed, please do so, and we'll see you again soon here at the Four Boxes Diner.
Orders up. Table 2A.